Hi, everybody, and welcome to the September edition of the Third Fridays podcast. The room is actually jam-packed because we are so excited to present the final prompt of the 2019 mock trial competition here at Lois. And I guess I should start off by saying that we do have our fearless leader, Greg Lois, in the room. He wanted me to say some kind words about him. Just like he always does. Greg, you're great, overseeing the program and allowing us to move forward as humans, attorneys, and paralegals, not necessarily all at the same time, but it's been a pleasure to be a part of this firm, as I'm sure my three guests here today will agree. So let's talk about mock trial. Today I have Joseph Melchionne, last year's winner of the mock trial competition. Welcome to the show, Joe.
Thank you very much. Pleasure to be here.
And so today we have our finalists, number one, Christopher Major and Monica Shea. Welcome to the show, you guys.
Thanks for having us.
Happy to be here.
Okay, so how it works here, part of the training program that we have set for our attorneys and paralegals is to present them with a random prompt. This year was actually a real-life case that we tried to mimic throughout the past few months, and this year we focused on actually a real case that we were successful in defending for our client. Judge Gregory Lois issued a reserved decision disallowing the claim. So for the first part of the podcast, we have Ms. Monica Shea doing an oral appeal on behalf of the claimant. Not in real life, because we don't do that work. That's bad. We represent employers here. But for the purposes of this educational exercise, the floor is yours.
Thank you so much, Christian. So I'm going to just start off by giving some background. The claimant, John Smith, worked at a concrete company as a concrete tester called We Do Concrete. The facts at hand here are essentially he got into his truck at the end of the day and, what happened was the truck rammed forward, slammed into a dirt embankment. He ended up getting injured, was taken to the hospital, and essentially they diagnosed him with injuries to the head, the left wrist, the neck, the back, the right leg, and as well as a concussion. So we originally
You did say that it was at the end of the day, though, right? So he wasn't actually working, right? So why should we even hear this appeal?
So the reason we should hear this appeal is because the claimant the claimant testified actually at the prior hearing where we heard the testimonies of both the claimant and the two carrier witnesses, his supervisor, Mr. Tony Cannoli, and his coworker, Mr. Joey Donuts. The claimant, he testified that certainly it was near the end of the day. However, when he had been clocking out, he was actually clocking out. So the reason that we should be hearing this is because even though it was near the end of the day, he actually hadn't left the job site at the end of the day. So this would actually be within the scope of the accident, I believe. So he, despite the fact that he had gotten into the truck.
Let's talk about it, right?
Sure.
So he's on the job site, and that's within the scope of the accident, right? Was he doing anything at the time that was in furtherance of his duties as a concrete tester?
Certainly it would be in sort of a gray area, and this is with respect to the carrier defense. It would have been definitely under a coming and going defense, which is where they allege that the claimant, was commuting and it wasn't technically part of his job duties. But as for us, defending that this claim should be established, we would argue that this is actually a gray area. The claimant certainly was getting ready to leave the job site, but as was testified by the carrier witnesses and the claimant, the carrier witnesses certainly, the site of the accident, he hadn't actually left the job site. So it was in that sort of gray zone where he hadn't left the job site yet, and you could argue it was actually within the scope of the employment because he's required to go there every single day. He hadn't left the job site. The dirt embankment was on the job site, so you could say it was simply a hazard of his employment. And if not for his employment, he wouldn't have been suspect to that hazard and the accident wouldn't have happened. Therefore, in our case, we'd be arguing that it does fit inside this gray area. It was within the scope of employment because it was a hazard that was solely within the scope of his job duties.
What about the medical portion of this claim? I mean, you mentioned all the body parts that were involved. I mean, does that play a role? Like, it seemed like it didn't matter because it was a legal defense that won the day. So you mentioned all these body parts, but why should we care about that?
Certainly. With regards to the body parts, that actually, I believe it has to do with another part of establishing the claim, specifically causal relationship. So with respect to the body parts, he was later first he was seen at the hospital where they diagnosed him with the body parts I mentioned before. And then shortly after, about I believe a month after, he saw a separate doctor unaffiliated with the hospital. We took the deposition of this doctor, and this doctor testified within medical certainty that he was sure that the injuries were causally related to the accident that happened at hand. And because of that, because the doctor has testified and the carrier actually hasn't yet produced an IME to rebut this, it falls within the scope of causal relationship, which is part of, I believe, Section 21 of the Workers' Compensation Law, which states that ANCR, accident, notice, and causal relationship need to be established to show that the accident at hand or the injuries at hand are compensable.
Okay, and you know, we're here as a mock board panel, right? I mean, this is not going to happen in real life because it's an administrative review, but you know, and maybe Chris, you can help Monica out here if this question is a little bit out of bounds. But you know, what's our standard of review here? What is exactly our role? You know, we're not the ones at the trial making findings of fact, so. How can we rely on, you know, arguments that are seemingly taken into account at the law judge level?
So case law is very, very clear, and it's been said time and time again that, you know, the law judge, as the finder and trier of fact, is entitled to great deference with regard to his findings. So I believe the standard is that the decision will be upheld unless there's no support in the record exists, or the decision was not supported by substantial evidence. And
so let me stop you there then. Monica, isn't there substantial evidence and support in the record that the claimant in this case clocked out, went into his truck to do a personal errand, and then the accident happened? Like, there's nothing that the claimant can say to rebut those facts, right?
Again, I believe this falls within the scope of accident itself, that gray area that we talked about before, where even if the claimant has clocked out, if it's within the scope of his normal employment duties, it's something that, again, is a special hazard that is restricted, something that he would have encountered only as a extension, essentially, or as the result of him either performing his duties or, within the scope of his employment in general. So in this case, again, even though he had indeed clocked out, he had given notice to his employer to clock out, he hadn't left the job site. He was actually seen, he was getting ready to leave, certainly. But the dirt embankment, which, if I remember correctly, almost all of the witnesses to the accident itself testified was an essential part of the accident, of the motor vehicle accident that happened on the employment site itself. He would not have likely encountered that as a possible hazard that could have caused the accident, if not for the fact that he was still on the job site.
Right, and it's kind of an odd legal standard in that, you would think it would be very cut and dry. Somebody punches a clock at the end of the day. That's it. The workday's over. But unfortunately, as with much of the law, there is a substantial murky area where the inquiry of whether the claimant was continuing to work, or rather whether the accident flowed as a natural consequence of his employment, doesn't end at punching a clock. And so I think what Monica is getting at here is that but for his employment, again, one of the witnesses actually saw him, Joey Donuts saw him putting tools in his truck. As far as he knew, the claimant usually punches out at 5. He may have still been on the clock. But the claimant was still on the actual job site. This isn't a risk that was shared by the general public at large. He actually drove into a dirt embankment that was on the job site, you could argue he hadn't even started his commute. I mean, he never even made it off premises. So it's the issue of punching in and out, sadly, for carriers is not dispositive of whether or not the claimant was continuing to work.
All right, I think we've heard enough. Joe, what did you think of that? I thought that was pretty good, actually.
I was very impressed.
I thought you guys hit a lot of points, and just for the viewing audience, one little trick that we pulled on them right before recording was taking their notes, so they could not look at anything to help. I thought that was great. Monica and Chris, you've done a fine job throughout the last couple of months to get to this point, and we're going to now move on to my favorite portion of the prompt, trivia.
You don't like the discussion portion?
Well, far be it from me to overturn the Honorable Gregory Lois. This claim is going to remain disallowed.
Yes.
Okay. Mm-hmm. All right. Chris, first question's for you. Whose idea was mock trial?
You know, I feel like I'm walking into a trap here, but I don't know if I'm being given a hint from behind the scenes. I want to say Christian Cison and Lauren Rella.
That was a tough hint from the producer. She kind of led you astray. The answer is actually Amy Figueroa. She was looking for ways to help our training move people to greater heights in their careers. And I am only asking that to attorneys because all the attorneys that are finalists were here when we presented the program, and I gave her credit for that 5 seconds because naturally I want most of the credit. But yeah, so that's incorrect.
Incorrect. Great.
All right.
Off to a good start.
Second question, also for Chris. Name one thing different about this year's mock trial program compared to last year.
There's a couple things, but I'm just confirming in my head things that we did not do last year. I don't believe there was a deposition of a treating doctor in last year's prompt, and I think as a fallback option,
alternatively,
yeah, having paralegals litigate is especially conducting cross-examination at trial and the oral argument portion. That was definitely new.
Mr. Melchionne, what do you think we should give him for that?
I think we should give him full credit.
Full credit. Okay. I would have given you half because you went with the first answer, which was wrong. But you'll get half. The other answer acceptable to the judges here was the use of New Jersey to come in and help us and learn from the New York team. Okay. So you are 1 for 2, Chris. Monica, your first question is, what was the name of the real-life claimant for whom this year's prompt was based?
I'll have to pass this one because I honestly don't remember.
Okay. Actually, you know what? I'd like that because then that means that you didn't go into our own files to help you prepare. So it showed some honest preparation, but the answer is Kareem Hagag.
To be fair, when you said mock trial trivia, I was all for actually studying the actual mock trial prompts. So it isn't that I wasn't prepared.
I never said you weren't. Never said you weren't. I actually said that you not knowing the name is actually substantiation that you prepared, like, intuitively.
In other words, full credit.
No. Okay, we have to be real here. 0 for 1. Monica, your second question, and I think you know the answer to this because you referenced it in your oral argument. What was the name of the claimant's supervisor, and who played him during the trial?
Oh, this is Tony Cannoli, and it was played by our illustrious Joe Melchionne.
Illustrious, very handsome, very intelligent Joe Melchionne. Yes.
Yes, that is correct.
Illustrious is a good adjective. That's a good one for Mr. Melchionne.
Thank you.
Okay.
But not the only one.
All right. So, Monica, you're 1 for 2, and the next question is for you.
Mm-hmm.
How many partners at Lois LLC played a role in mock trial this year?
Was it not all of them?
That is correct.
That's correct.
She had a little John Marzola contribution at the trial as a judge. Snuck him in there. Okay, Chris, your question. Name a defend from day one strategy recommended in prompt 1, the client conference call.
I'm a little hazy on the prompt here. What are we?
Am I allowed to sub in for him?
What a defend from day one strategy mentioned on the
recommended by the attorneys to the client. The clients were the judges, if you remember that prompt.
Yeah.
The call comes in with the history of the case, and the attorney, as we do, make recommendations, right?
Mm-hmm.
Now, as a devout follower of defend from day one, like I know you are, can you name one strategy mentioned by an attorney during that prompt? Would you like some help from Monica?
If that's not going to result in a deduction of points, sure.
It's a very good question.
I think that if Monica gets it, we could award Monica half a point.
What? Okay, no.
Well, you're not competing against Monica, right? So maybe if Monica gets it, then Chris gets half, and Monica gets
I feel
half.
as long as Monica gets something.
Yes, of course.
Okay.
Well, I mean, Chris, you can just take the next 20 minutes to decide on an answer.
Yeah, I mean, it's such a broad question. I mean, obviously, we want from the employer any sort of documentary evidence that they've prepared, especially in this case, the accident reconstruction report that they mentioned. So we ask that they send us everything. We ask that they give us their adjuster contact information if we're talking to the employer specifically. I mean, we get started preparing the PH 16.2 right away to ensure all defenses are preserved. I mean, there's a 100 different directions you could go in terms of best practices in defending from day one as to what was mentioned during the actual client call.
Exactly. The question was name one strategy. Right. And the answer I have written on my sheet says, accept any reasonable answer.
Okay.
I would have given you 2 points if you mentioned a site visit, but you gave 3. I'm going to give you 1 point for that. Okay? Good job not ceding to Monica. Got a little heated there. Okay, Monica.
I'm trying to help.
Monica, why was Dr. Fraud's medical report sufficient to meet PFME?
I'm not sure if this qualifies too much or qualifies too little, but from what I remember, he asked the claimant. One of the things he did, for example, is ask the claimant his I'm sorry, I'm blanking on the word here, but essentially he asked the claimant to recite to him the events that occurred within the accident. He reviewed the claimant's hospital records, if I remember correctly. He also he reviewed the hospital records. He asked the claimant his version of the events that occurred, and
we'll take that as a correct answer. I also have accept any reasonable answer, which is a joke on the system itself, because PFME is a standard that is so low and it's ruining the system.
Well, so this is actually something that's kind of interesting, because you played the judge when we did the pre-hearing conference portion of that, and I argued, we only needed I was the claimant's attorney, and I remember arguing, all we need is a medical report referencing an injury to get past this threshold. And you said, well, Mr. Major, what is the standard for prima facie medical evidence? And I thought, I was pretty sure it was just a medical report referencing an injury. But then I went back and dug into it some more. And, my understanding is that it needs to be signed off on by a doctor. There needs to be an actual physical examination. And these are things that we do frequently argue in terms of defending cases, where someone will come in with an RN's note or a physical therapy note and try and rely on these things. And we do sometimes, despite the joke of a system, we do sometimes prevail in our argument that the claimant has not satisfied this very, very low burden.
Well, I mean, underneath that, your description of what you believe to be the standard, would a medical report signed by a doctor referencing an injury but not referencing that it was work-related or it happened on the job, would that constitute prima facie medical evidence under that theory?
I've gotten burned by that very same report in prior cases, and that's an issue to develop on cross-examination. That's why we request cross. And we do argue. We do say he never at one point says this occurred on the job or that this is causally related. Those are arguments we make, and in certain jurisdictions, maybe you will prevail, but oftentimes my experience has been such that they use this very low burden for PFME just to move forward with trial.
That was a good discussion. That was not planned. Good job, guys. Okay. The next question is for Chris. Is it better to cross-examine the PFME doctor regarding an incorrect history received or discredit the diagnosis itself? It's a tough question.
So I'm going to say cross-examine them regarding the history of the injury itself, because a diagnosis is a highly subjective medical opinion. I could diagnose right knee internal derangement. You could diagnose right knee sprain, and it's a losing argument, in my opinion, as a lawyer, to poke holes in a doctor's medical findings. That said, the whole point of a medical opinion in establishing a claim is causal relationship. And if this doctor has we literally had a case disallowed on this last month where the claimant said the car in front of her backed up into her car. She said to her doctor that she was rear-ended. That was enough to disallow the case. The doctor had a complete incorrect mechanism of injury. And if you don't have the right mechanism of injury, you don't have causal relationship, and there goes that element of ANCR.
I think that's a perfect answer. Also, just using background stories of things that you did well on to boast about your goals and your triumphs. Really, the only reason I asked that question is just to remind everybody to defend from day one. But that's another point for you, Chris. It's now come to the hardest question of the day, and both of you are going to answer it by taking turns, because there are 8 answers.
I disagree. I think the last question is the hardest question, but I'll let you be the judge when we get there. When we get there.
Oh, okay. I think this one's pretty hard. Name the order of paralegals who spoke on the record at trial.
It was Kara first.
That's correct.
Okay.
Well, I mean, if you want to keep going, it's a team answer.
Yes, please.
It was Kara who was the direct, who conducted the direct for the claimant's testimony.
Yes, Kara Malinowski, great paralegal. Who's next?
Are we taking turns?
Well, I mean, you could go in any.
Okay.
If you know the answer, then
okay.
go
The
ahead.
next one was myself, Monica. I conducted the cross.
Monica Shea, great paralegal. Okay, 2 for 2. Who is next?
So that was
the
claimant's testimony. So next up is Joey Donuts Tony Cannoli, because I know Rocco ended up going last, and he had Joey Donuts in terms of cross-examination, not in terms of statements on the record. So who had Tony Cannoli? Do you remember, Monica, who went 3rd and 4th?
My money's on Monica, personally.
It was Andrew and it was Megan
Ooh.
who conducted the next 2. And then Lourdes was paired with Rocco.
So just to be clear for the record, who would be the third? You said 2 names.
The third would be... I think it was Andrew who was 3rd, and then Lourdes who was 4th.
Now, Joe, you were Tony Cannoli, right?
I think so. Yeah, I was Tony Cannoli.
You know, the great accent, right?
Yeah, excellent Boston accent. By way of Staten Island, by way of New Jersey.
There's always
Poland.
acting if this law thing doesn't work out, Mr.
I don't think so.
So, I do believe that Andrew was a person who asked you questions as a witness.
He did.
But I don't believe that Tony Cannoli was next.
Right. That's the issue.
That's why the third answer is incorrect.
Right. Your memory is very good. Better than I would have been able to do. I tell you that, but...
Okay. So, the 4th paralegal would then be who?
Well, so...
I can't give you any more clues than that. I just basically told you the order of the witnesses. So,
then it would be Rocco. Well, because if you're saying Joey Donuts went before Tony Cannoli,
Right.
and I know
Rocco
had cross of Joey Donuts.
That would be incorrect because Joey Donuts is an employer witness, and the direct was done by Megan Holloway.
Whoa.
Oh, Megan was third. Oh, Megan was third.
Yes.
You got it wrong.
Yes.
So Rocco is correct. You are
Yes.
correct.
Okay.
First
The cross
mistake I've
came-
ever made. Damn it.
The cross came after the direct.
Okay, Rocco's correct. Who's after Rocco? Rocco Crincoli, great paralegal. Megan Holloway, great paralegal.
So this is the one. This is the one we just had.
Yes.
Sorry
I
for
want to make-
misleading you with the Joey Donuts going last. I remember Rocco sitting there for a while. Okay, so
Probably all the
I
great
trusted
prep
you.
work you did, Chris.
So we have Megan
So-
and Andrew,
I
right?
just need to think about who
Who the witness?
order.
Right. Who is the witness? I think that's going to be the
The
marker
witness-
that's going to help you.
Well, the witness was Tony Cannoli, who was
Correct.
last.
And then who did
And I'm
direct?
just trying to think who did direct and cross. I know the names. I want to make sure I get them in the right order.
One of them wore a baseball hat.
Yeah, and
No, I absolutely know the names. The issue is more the order, and I want to make sure I get that correct of who did what.
well, so one of them, I believe, was critiqued for making no objections whatsoever on the record.
that I also remember. I know
so-
know who it was.
So we will not specify who, but you would anticipate.
50-50 shot here. We got to get an answer to keep the program moving.
Can we skip to summations and then come back, or is that
No,
not an option?
no.
I'll give you a
Okay.
hint. This person is a great paralegal.
I really got angry that you were going to give him a hint. But yes, keep going.
He wouldn't have while you were standing right next to him.
I'm gonna say just for the purpose of moving along, Andrew and I'm sorry, Megan then Andrew.
No. It was Lourdes.
I'm sorry.
Lourdes, who was paired with Andrew.
So Lourdes then Andrew would be my guess.
Is that your final answer?
You disagree?
Can only be one other option.
Who went first?
Okay, that's enough time.
All
It was
right,
Andrew, then Lourdes. Andrew did direct, Lourdes did cross. And I'm assuming that you guys know who did the brilliant summations at the end. Who went first?
It was Jen, then Nick Fortino.
Great. Okay, so you guys got 1, 2, 3, 4, 5 out of the 8. It's pretty good. I don't think I would have been able to do that. That was
No,
just
me
really
neither.
hard.
I think the thing was the
No.
order. I know which two paralegals were teamed up with what witnesses, but the order, going in order, definitely threw me off.
Okay. Final question. Mr. Melchionne thinks it's the hardest one.
I think so.
Okay, why don't you ask it?
Okay. I have a feeling I know why you want me to ask it, but I'll ask it anyway. Who is the best attorney in the state of New York?
Greg Lois.
That is an acceptable answer. I have written down Christian or Greg.
There was let the record show
I'll
there
say you,
was
Christian,
zero
so we have one
hesitation.
All right. That was a pretty good trivia round, guys. The only final thing I have left is the constructive criticism portion of the show, right? So, Chris, you've been through 2 of these programs. You came in second, really by a hair last year. You did get a nice plaque for it, though.
Oh yeah, proudly displayed.
In the box in front of your desk, yeah.
Monica, this was your first participation in the program. So if you guys could give maybe some feedback or a recommendation how we could make it better next year, that's what we're always looking to do, is improve the product.
So we actually had the opportunity to discuss this a bit, and I believe there was a meeting of the minds regarding where this could go.
Tread lightly.
So, well, no, it's constructive criticism. So
Maybe we should start on complimenting the program a bit first. It was
well,
excellent.
that's where I was going. So if you remember, one of the things that was mentioned at the award ceremony was how impressive it was that I squeaked into second in light of having approximately 3 or 4 months experience at that time. Now,
Are you beating
Does he
the
get an extra
program
point for
or
ingratiating
himself?
himself?
well, so here's why I bring that up. At the time, I was not overloaded with cases. I was still sort of feeling my way out, and this was a perfect learning experience. The reason I was able to get to where I got over the course of that program was because I was able to sink my teeth into it and put the time into it and use it as the opportunity it was. And I believe at the heart, why do we do this? Why would we have a mock trial is something that I think perhaps too many people ask. And at the end of the day, it is a learning experience. And it's a learning experience to the extent of both best practices and to learning about each other.
All right, we know, I think that we all agree that the program is an integral part of what we do here at Lois.
Right.
And I think that we all agree that it's important because it kind of reinforces best practices. We made improvements from the first year to the second year. So what we're asking is, based upon those improvements and based upon your experience as someone that has gone through both, what are some constructive criticisms going forward that we can implement to make next year's program even better than this year's?
So I think one thing that Monica and I absolutely agreed on was having the paralegals litigate was tremendous, and that was a big difference from last year. But I think something that you struggle with when you're conducting a mock trial is having too much busy work, because that dissuades people from participation. Everyone's got their workload, and everybody's sort of struggling to make time for it. But the problem is when you have people doing busy work, the question becomes why? And it's also the case with just sending out letters or meeting deadlines or filing stuff with the board. If the paralegal doesn't ask why we're doing this, there's no context for it. There's no plan B. There's no personal stake in what's occurring. And I think the really important thing about mock trial this go around was that the paralegals were learning why they're doing the things they're doing. This is when you put in the legwork behind the scenes to arrange for cross, to prepare witnesses for trial, to get all of this stuff to fruition. This is what happens. This is what your attorneys do with it. They take the ball and carry it across, the goal line.
And I think definitely the litigation portion of it, where the paralegals really got to jump in and kind of see it in action, get to experience it in action, get to take their own hands and really jump in and get the experience out of that. I think what we discussed was sort of the earlier portions of prompts 1, and then the early ones of, I believe it was 2 and 2, correct?
2 and 3.
2 and 3 with the deposition, the client call, and the pre-hearing conference, correct. So with those, the paralegals, they got to do a bit more writing, but I think what we discussed was sort of getting more hands-on like we did with the litigation part. With the litigation part, the paralegals got to go into the experience of seeing what the attorneys really do in court, whereas with the earlier portions, it was more you were there as an audience member to sort of take notes. We discussed sort of especially with the client call, I believe, maybe the paralegals having more of a hands-on portion in that, like the litigation part. In where the litigation was litigation, maybe the paralegals taking the client call and then the attorneys getting more into a coaching role would help the paralegals see what the client side of the business is like, and the attorneys likewise would get to refine their abilities in coaching somebody else how to really refine their technique and speaking with the client. And this could also be passed on to, say, newer, when they have to coach newer attorneys with speaking with clients.
I don't mean to interrupt. I think we understand why you found the experiential litigation part fun, and that's great that we were able to add a little bit of fun. But in reality, the paralegals are not going to litigate. And I understand that was an integral and important part of what we did this year. But I think that to further delve into this, the busy work or the written work I think you were referring to, do you feel as a paralegal this year that it adequately reflected what you do on a daily basis?
It's a good question. Good question.
Because I do think that going forward we can't eliminate that, because we want to be able to make sure that the paralegals are getting the support they need for the things and the activities and the duties that they do every day.
Not to also put any less light on it, but that was a great answer that you just had before that question.
No,
So
I agree. That's why I said let's dig a little deeper.
Yeah, and definitely. And
right.
that's why,
Did it make it, was it adequate? Was it an adequate representation of what you do, right? That was.
Yes, absolutely.
Yeah,
Okay.
and definitely that's why we touched more on the client call as opposed to, say, the deposition or the pre-hearing conference, because the pre-hearing conference and the deposition summary, I think, are more akin to the busy work that we actually do in the course of our duties, while at the same time sort of touching on the busy work that the attorneys do as well. So there's like that intersection in between those two.
So what, if any, what modifications, if any, would you make to the written aspect of the paralegal aspect of the mock trial for next year, if any? You could say none. That's an acceptable answer.
I think a bit more guidance in terms of next actions would definitely be helpful with regards to this, because as an attorney, your job is to provide, solid next actions for the client to decide if they want to take that. With paralegals, we don't get as much, I think, experience in determining next actions or experience in understanding, why these specific next actions, and getting more, I suppose, guidance or coaching to really understand what are the next actions that are the most significant and why we're taking them would not only help, with this program succeeding in helping us develop our own abilities, but really applicable to when we're doing normal paralegal busy work, such as writing our own pre-hearing reports.
And this is why I sort of led off with my portion of it the way I did, is, I would caution against describing the paralegal litigation portion of it as fun. While I'm sure it was fun and, everybody got a chance to flex their muscle and maybe even have a few laughs every now and then, the important thing for me out of that was context. It is very difficult to have a personal stake in the game if you don't know why you're doing what you're doing. And the one thing you cannot teach uniformly across the legal profession is caring. And it is anyone can meet a filing deadline, anyone can send out a letter. What makes us different is the ability to provide unique legal recommendations and move the ball forward in ways other people don't. And when the paralegals are doing things just for the sake of doing them, because they know it's supposed to be done, without having any context, it just becomes rote. There's no end game to it. And I think that's where the litigation portion was important, is you understand why you do the things you do, and it makes them feel more valuable to you. It's more tangible.
I agree with everyone here. I think that's definitely good to know why you do things, because then you can do them better, right? Love what you do, and you'll never work a day in your life. But we don't want to be here for another 2 hours. So this is Christian Cison with Joey Melchionne, Christopher Major, and Monica Shea, reminding you to defend from day one.